And good afternoon, everyone, and welcome to the Australian Business Lawyers and Advisors webcast on managing restructures and redundancies. I am Joe Murphy. I'm the National Managing Director for Workplace, and with me today is Emily Slater, one of our Senior Associates. Welcome, Emily.
Thanks, Joe, and hi to everyone watching.
So today, we'll get right into it. We want to talk about redundancies and restructures, and one of the reasons we do this, and we tend to do this webcast annually, is that redundancies these days are business as usual for many businesses. They're no longer simply for times of crisis when businesses are either financially or the economy's in a state of flux. They are business as usual for businesses to restructure their businesses and to build in efficiencies into their businesses. So it's not uncommon to even find that some businesses these days will even have employees whose jobs are simply to be all about redeployment of employees. I know that lots of the big banks have them. In fact, my wife used to perform that role for a while with one of the big banks. It's business as usual. So it's important we talk about this. But even for small businesses, it's not business as usual. It is those businesses that also need an understanding of where the legal boundaries lie and where the practical stuff begins as well. So we're going to talk a little bit about that today. And what we're going to talk about is, when is it a redundancy? Do you have to consult? What protections are available for you when you do the right thing around affecting a redundancy? Deciding which employees should be made redundant when you're talking about more than just one employee, because when there is a restructure involved, it often involves more than one employee, and sometimes it involves employees in multiple positions. Your payment obligations are really important on redundancy. So I have to say that we do see quite regularly businesses get this wrong, and that's not a criticism. It is because the workplace laws are very complex, and when we talk about the entitlements that we're going to talk about today that are payable on termination and including in redundancy situations, it's very difficult for businesses to get it right because they all have different rules. So we'll talk a little bit about that. We've only got an hour today, so we could spend all day on this stuff, but we'll shoot through some of this stuff quite quickly. If you have any questions, make sure you send them through. We've got our helpful moderator, Tori Smith, who is sitting out there trying to locate questions that we can deal with. And later on, after the event, we'll try and deal with some of the questions as well and send you emails about them if we can. We also want to talk about, apart from payment obligations, but your notification obligations, because there are notification obligations, and also conducting a bit of a redundancy process, which will be, again, reasonably high level given the time we've got today. So, Emily, I might invite you to talk a little bit about what is a redundancy.
So basically, a redundancy arises where you've got a situation where someone's job that they perform is no longer required. The focus is on the job itself, not on the individual performing the role. And a job can no longer be required as a result of a number of different factors. It can be because of operational changes, downsizing. It could be that there are technological advances which mean that the role that someone's performing just isn't needed anymore, because there could be a piece of machinery or some technology that could do that role or do the duties that role was typically performing. It often arises where you might be downsizing a team, where you can build in some efficiencies, and the duties that were performed maybe by 5 people are now only needed to be performed by 3 people. And again, technology can also assist with that as well. So it's where you're looking at a scenario where someone's job or that particular job is no longer required to be performed. So the focus is always on the job itself.
And I think, you'll see in our list of items here that we've included, one of the circumstances might be a removal of a position from a structure. That job will disappear usually from the structure in the business. It might even be a very small structure, but it can be a very large structure. But also it involves a question about what happens to the duties then. And it is really important that whilst Emily says that the job is no longer required to be performed by anyone, sometimes some of the duties will still exist, if not all of the duties in some circumstances. So it is okay for those duties to still exist. It doesn't mean the job is still required to be performed. The job is the collection of duties that forms that role. And you will often find in a redundancy situation that those duties will be distributed to other roles. So it's perfectly okay to do that. There may be an examination by a court or a tribunal about that at a later date. So you've got to be careful that it's not a sham redundancy. And I use that in a general sense, sham. It's not a legal term. There is a legal definition of sham, but in this circumstance, what I mean is, a ruse or a way to get rid of someone. We're going to talk a little bit about more this afternoon. I just wanted to touch on ordinary and customary turnover of labour. It is a very, and I've got in brackets there, limited. It's a very limited circumstance in which a redundancy or a termination may arise. It is an exception to redundancy, meaning that if the employment of the person comes to an end as a result of the ordinary and customary turnover of their labour or their role, and that usually is associated with end of contract type terminations, then redundancy pay is not usually payable in those circumstances. But I want you to be careful about that. I said end of contract, and it's very limited to circumstances where that is the ordinary and customary turnover of that type of work in that type of industry. And it won't usually involve, and in fact it often won't involve, circumstances where you've got rolling contracts over many years with organisations where all of a sudden you no longer have the contract after a series of contracts, and that person's employment comes to an end because of that contract coming to an end. That will generally still be a redundancy. So I want you to be careful about ordinary and customary turnover of labour. Now, how they happen, we've got legitimate reasons and illegitimate reasons. Some of the legitimate reasons?
Yeah, so just going to what we sort of touched on a bit before, obviously technological change can be a reason why someone's role is no longer required to be performed, or maybe the duties that they were performing are being divvied up amongst other employees. Also, an outsourcing arrangement, we see that a lot. The test is whether, or the focus is on whether the job is no longer required to be performed by the employer. So that's limited to the employees of the business at that time. So you can have redundancies arising where there is an outsourcing arrangement and that particular role is performed by an external service provider. It also comes up where you're looking at businesses that are winding up, undergoing administration with a view to closing or being liquidated. Sale of business, that's a really common scenario where a redundancy can arise. And then, the usual kind of restructure and operational requirement, change of process. Those are the most common reasons that we see.
I think it's pretty, I think, you and I both think it's pretty easy to find to build a business case for a redundancy. But there are those illegitimate reasons that we come across from time to time. So let's hear about that.
So what we're often asked, or I shouldn't say often, what we're sometimes asked is, there may be a problematic employee and we'll be asked, can't we just make that person's role redundant? And usually the first question that we'll then say to the employer is, well, do you still need that role to be performed? The answer is usually yes, but we're looking for a way to kind of move that person out of the business. And when that happens, say we get involved at a later stage, maybe after they've gone through this process and they've exited the person from the business and then they're facing some type of a claim. If you go back and look through the process, it sometimes can be quite obvious that what was happening really was a way of trying to move that person out, and the redundancy wasn't actually genuine. The role's still required to be performed, they're advertising for it now, and then the employee who was moved on then comes back and says, hang on a second, that's my job that you're now advertising after I finished up a week ago. So we come across that a fair bit as well.
And I think when it comes to making people redundant in those circumstances, the Fair Work Commission has looked at a number of cases where people have filed applications for unfair dismissal outside of the 21-day time limit. That's not entirely a safe zone, because outside of the 21 days you can still make an application if the circumstances are exceptional. And there have been a couple of cases over the years where employees have discovered their jobs that have been advertised. And the Commission, in my view, would consider that to be an exceptional circumstance. potentially require or permitting the Commission to consider extending that 21-day time limit to allow them to bring an unfair dismissal. So part of that strategy, and the question we ask, as Emily said, we ask the client around, is this a job you require to be done? When the answer is yes, then redundancy is often not the way you can go about it. There are also taxation implications. Because if you tax a redundancy quite beneficially for an individual in most circumstances, if you are making someone redundant for a reason that is not genuinely a redundancy, and I'm not talking about genuine redundancy within the meaning of the Fair Work Act, just the general term genuine redundancy. If you make someone redundant in those circumstances, there is a risk that at some point the tax department might look at that and say, well, you've taxed that incorrectly because it wasn't really a genuine redundancy. You still needed that job to be performed by someone, so you should have taxed it appropriately. The other one is around injured workers, and that is, someone's off on workers' comp, and they've been off on workers' comp for a year, and you decide they're on the list. That should not occur. It occurs, though. It does occur. It should also be something that you should carefully consider in the other direction, and that is that person should also not be off the list of considerations because they've made a workers' comp claim. So you're damned if you do, you're damned if you don't. So what you have to do is treat them as best you can as an employee who would normally be at work and be on that list. Not because they've made a workers' compensation claim that they're on the list, or because they've made a workers' compensation claim that they're off the list. That can be quite challenging for businesses, because when we talk later about selection processes and we talk about looking at someone's performance that is objectively provable as best it can, that can be quite difficult, someone that's been on long-term workers' comp. We might talk about that a bit later if we've got time. So when we look at genuine redundancy and other protections, now I'm talking now about the statutory definition of genuine redundancy in Section 389 of the Fair Work Act. The first question is the one that Emily talked about earlier, and that is the person's job is no longer required to be performed by the employer, and that is the job itself is no longer to be performed by anyone by the employer due to operational changes to the employer's enterprise. Now, that can be a decision you make. It doesn't need to be driven by financial hardship by the business. It might be that you just decide that, well, you're going to engage in downsizing because you feel like it. You're going to engage in operational efficiencies because you've decided that within your own mind that that's right. Whether you are correct about that in terms of operational efficiencies is entirely irrelevant, as long as you honestly make that decision and it's not for an unlawful purpose as the one we were discussing earlier. If you go down the path of making that decision due to making changes to your operational, to the operations of your enterprise, and that person's role is going to be made redundant, the next question is, are they an award-covered employee? And if they are an award-covered employee, then you must comply with the consultation requirements in the Fair Work related award, modern award that is, and the relevant modern award that covers that employee. Now,
or enterprise agreement.
Yes, and there's another requirement, of course, beyond that, and that is if you've got an enterprise agreement, then you must comply with the consultation requirements in that enterprise agreement. If the enterprise agreement doesn't have a consultation provision that's compliant, then the model consultation clause will usually apply. The Commission will usually have picked it up at the time of approval anyway, so you'll know what to do with that. We'll talk a little bit more about consultation requirements specifically when we get to another slide. The next requirement is, can the person be reasonably redeployed into another role within your enterprise or the enterprise of an associated entity? And again, we'll have a slightly closer look at that. But those three items, the three first points that we've got up there on the screen, if you tick off on those requirements of terminated due to the job no longer being required to be performed by anyone, and it was changes to the employer's operations. Secondly, that you've complied with your consultation requirements, and thirdly, that you've complied with your redeployment obligations to examine redeployment and redeploy the person if you're required to, but if it's reasonable to do so. But if it's not, then you are protected from unfair dismissal. Now, that doesn't mean they can't file an unfair dismissal application, but it means you can defend one if you have complied with all of those requirements. And we're going to talk a little bit more about what you need to do to comply with those requirements. I've got there another point on the screen, and that is payment obligations. If you don't get those right, it doesn't mean you don't have a genuine redundancy. What it does mean, though, is that you significantly increase the likelihood that that person will bring a claim. Not just an underpayment claim, but what we often find is that they bring an unfair dismissal claim, and in the unfair dismissal claim, they will state the fact that they've been underpaid or underpaid incorrectly. And it can be a whole range of entitlements: notice, redundancy pay, long service leave, annual leave, whatever accrued entitlement they've had that they expected to get a payment in relation to. So it's really important you get that right. And again, we're going to talk a little bit more about payment obligations. Consultation requirements, Em?
Yeah, so there, in every modern award, it will have a clause. It's usually, I think, clause 8, 7 or 8, the modern award consultation requirements, and they are quite specific in what they require employers to do. They can be quite onerous for some businesses, again, depending on the size of the business. But basically, what the modern award consultation requirements require of you is, once you've made a decision around making a major change in an enterprise, and that major change is likely to have significant effects on employees, and significant effects is also defined in the clause as being, as including termination of employment. It can be other things as well, but for the purposes of what we're talking about today with redundancy, that's the key takeaway of a significant effect. Then as an employer, you must consult with those employees who are going to be affected by the change. So it's in every modern award. It's also in enterprise agreements because of the process of booting an enterprise agreement against the relevant modern award, and the model consultation clause, which will be inserted in if there's not such a clause in an enterprise agreement. Obligations to consult also arise, or potentially arise, in company policies, although we see this, less and less. And sometimes in a contract of employment, although we would not recommend that an employer has onerous or any consultation contractual obligations to an employee. So they most commonly arise as a result of a modern award or an enterprise agreement. And what they require you to do is consult with employees, so meet with your employees, provide them with all relevant information about the nature of the change, the effects, the potential effects of the changes on the employees who are going to be affected. Invite those employees to provide the employer with any feedback, usually called the opportunity to consult or respond. And then obviously once you've gone through that process, the employees have had an opportunity to have their say. Only then would you make your final decision in relation to the redundancy, after considering any feedback that you might get from the affected employees. One aspect of consulting with employees that we often see that employers sometimes inadvertently miss is giving the information to the employees in writing. Often there'll be this fantastic process. You'll bring all the employees in, they'll meet with the employees, they'll give them all of the relevant information, the union's involved, but then the information that is presented to the employees is just done verbally, and there's not information given to them in writing, and that's a technical breach. It doesn't necessarily need to be too fatal, but it can be a problem that employers run into once they go through that consultation requirement. So it's really important to carefully review that clause in the modern award and follow those obligations. There's an exclusion. Joe might want to have a chat about the agreement and award-free employees and how that works.
Look, subject, of course, the award, the Fair Work Act consultation requirements are not applicable to award or agreement-free employees. So therefore, they can sometimes be dealt with, or in fact, they can often be dealt with, and certainly from a legal perspective, in a swifter fashion when it comes to redundancies. So, there's the requirements that Em's already talked about in terms of starting a consultation process with your employees as soon as is reasonably practicable after you've made a definite decision to make major change in the workplace or implement major change in the workplace. That doesn't exist there for award or agreement-free employees. So, You've got to be careful though, because you will have, in most workplaces, particularly big ones, a mix of agreement and award covered, or one or the other, employees in the workplace, and then you'll have agreement or award-free employees. And so usually our advice in relation to a mixed workforce is to treat the award or agreement-free employees as if they were award covered. That gives them, certainly from a cultural perspective in your workplace, there's an egalitarian approach. When it comes to employees, you're treating them equally. They feel respected by that. I know that sometimes there's a desire for businesses to remove people from the workplace as quickly as possible during a redundancy process. I get that. I understand it. And I've seen the ramifications of people sometimes not being removed quickly from the workplace. It is challenging because not only is it, as Emily's already pointed out, sometimes an onerous process for businesses, but it can be a costly one, and not just in terms of financial cost, but in terms of cultural cost to the organisation. So it's really important when you implement a redundancy process that involves consultation, that you have a plan around that. And the plan's not just about consultation, it's about communication, it's about engagement, and it's about clean up at the end. But we'll talk about that when we get to the slides. So Em's already taken us through most of this. We've got a slide there for you. You'll be able to get your hands on the slides after the event. You'll get sent out a link to that so you can go through and have a look again. But you'll see here we've got a slide that covers off on the points. And the only thing I'll add to that is that there is an exception to all relevant information, and that is confidential information relating to the business. And that would be, commercial in confidence documents would fall, or information would fall into the scope of that. And that would be business strategies and the like that are not really the business of the individuals who are being made redundant. It is really around your business strategy. Those documents are generally considered to be commercial in confidence documents. They won't be information that has gone out in your annual reports or that you've already distributed by email and the like. Those things, of course, are already into the public domain or certainly distributed amongst employees. But that's something that you can consider when you're talking about all relevant information. So the point I would take away from this is really when you consider all relevant information being required to be provided in writing, the carve-out is confidential information, which to me suggests that you should give them what you can and only hold back what is confidential information. That way, you best protect the business as you proceed towards the redundancy and after the redundancy, and you also engender still that ongoing relationship of trust with your employees as you bring certain individuals' employment to an end by way of redundancy. Emily talked earlier about the requirement to consult with affected employees. That doesn't necessarily mean only employees who are going to be made redundant or that you have already identified as potentially being the ones that are likely to be made redundant. That would, in theory, and has extended to a broader range of employees who may be affected. So you need to consider that when you think about employees who might be still around.
Yeah, because employees could be affected by the fact that their workload's going to increase a little bit, that their duties might be changing to, take on parts of the duties of the role or the roles that were being made redundant. So there are effects on those employees who are remaining and continuing to work there. So it's a good idea from a best practice perspective to also consult with those employees.
I think I mentioned earlier about having a strategy in place and having a strategy to deal with employees through the consultation process around communication. Part of that communication is not just the group communication. When we talk to clients about this, we also talk about dealing with the individuals who are affected in the way that Emily's just talked about. When an individual's job is going to change itself, it might not be significant enough to change their job so much that they would require, a significant promotion or a significant pay rise or anything. But you need to consider whether or not that person's job does change significantly enough so that it does create a problem for you through your process or after the redundancies are effected. You really do not want that to impact on your culture in your workplace any more than it needs to. So when it comes to redeployment, now I've got the first point we've got up here is it's only required for dismissal protection. And that is, I mentioned section 389 I'm not going to mention lots of sections. I know people don't like lawyers talking about sections in an act, but it's an important section in the context of redundancy protection or genuine redundancy protection when it comes to unfair dismissals. So I talk about section 389. They're the 3 points. And the third point is the redeployment option. And that is if you want to be able to protect yourself in an unfair dismissal claim because it's a genuine redundancy, then you need to have considered whether it's reasonable in all the circumstances to redeploy that individual into your business, into your enterprise, or into an associated entity to your enterprise, a related company. The correct terminology is associated entity, but generally people call it related entities. I've got another dot point here about reasonable inquiries internally. You really do need to go beyond sitting in your office and thinking, oh, we don't have any jobs. If you've got a larger organisation which divisions, it would be our recommendation that you do consult within the leadership team or within the appropriate people. It might be individual HR business partners, it might be line managers, operations managers, there might be a whole range of people on that list. You would consult with them about what available roles are available right there and then, whom or what roles might become available within the coming weeks, so that you can properly say that, well, we examined whether or not there are any opportunity for reasonable redeployment.
Yeah, and this was considered in a case earlier this year where an employer was going through a redundancy process in relation to an employee, didn't do what Joe just mentioned before, which was sort of look more widely within the business and the business operations. There was a role that had been advertised interstate, still in the same company, but it was at an interstate arm of its operations. And the employee successfully appealed a first instance decision that the termination was not harsh, unjust or unreasonable in an unfair dismissal claim, because he was able to put on some evidence to show that there were redeployment opportunities for him at this other location, and the business had given evidence, oh no, we didn't have any redeployment opportunities, but they actually did. They just didn't consider more widely in the business. And so that decision was able to be appealed, successfully appealed, and was remitted back to the original commissioner to make a final decision. So
yeah, look, this is a challenging thing for some businesses, because a range of things arise, or a range of issues arise, and Emily's just talked about one of them, and it's relocation. It's important to remember that while it might be important for you to, or it might be incumbent upon you in order to meet your obligations of redeployment, reasonable redeployment considerations, it might be incumbent on you to actually talk to that individual or consider that role. You do need to consider these roles that might be, at another location. Now, we were talking about South Australia in that one, was it?
the job was in WA.
WA, okay. So even a little bit further away. But sometimes you might be looking at roles that are international. And this is the important point with the associated entity item that we've got here on the screen. You will have associated entities with some of your businesses that are international entities. And in those circumstances, you may be required to consider whether or not it's reasonable to redeploy the person to that role. The next question you've got for me is, do I have to pay for them to move overseas? Well, subject to your policies and procedures and your contractual arrangements, and some businesses do, load themselves up with obligations around paying for people to be relocated. But putting to one side those special arrangements that exist in some businesses, you are not legally required to pay for their redeployment. You are not legally required to pay a rental or a travel or a relocation allowance where one does not exist in a document. There's no general legal requirement to do that in terms of the redeployment. There's another consideration we've got on the screen here is inferior roles. It is always our recommendation to consult with the individual about inferior roles. Yes, theoretically reasonable redeployment considerations can be conducted by a business without consulting with the individual, but I think that the risk exponentially rises in circumstances where you have not spoken to the individual. I'm not suggesting you offer them the role. I'm suggesting you engage in a discussion with them about whether or not they would like the role. And that can be drawn out sometimes by an employee umming and ahhing and balking at the role and not quite answering your question. Are you interested in this role? Is what I usually recommend to clients to ask the individual. And to get a straight answer from the individual, yes or no. If the employee says yes, then you need to head down the path of considering whether or not it's reasonable for you to redeploy that person into that role. And if it's not, then you need to have a reason as to why it's not.
Yeah, and some of the factors that you would take into consideration if you're looking at whether or not it's going to be reasonable to redeploy someone into a role is their level of training, the expertise that they've got, the skill set that they've got, whether the job is similar to the job that they were already performing. And with issues such as training, whether or not someone is able to do the job if there's just a little bit of retraining required, a bit of skill refresher, it might be reasonable in those circumstances to consider redeploying that person into the role. So there'll be a number of factors that you'll need to look at that go to whether or not objectively it is reasonable for them.
Thanks, Em. And now moving on to selection processes. Now, we've already talked about whether or not the employer requires or no longer requires the job to be performed by anyone. But when it comes to making someone redundant, we use that terminology. You made someone redundant. I was made redundant. It's not really the correct terminology. You actually make the role redundant. The person's employment comes to an end because of the role becoming redundant. And that is because the employer no longer requires that person's job to be performed by anyone. So it's important that we start with that. The focus is on the role, and the focus is on that's part of the reason why also, terminations for performance or conduct is not appropriate in the circumstance of redundancy. They need to be dealt with as performance or conduct terminations. I do have a view, however, that there are circumstances in some businesses where someone's poor performance is so significant that it's rendered the role ineffective. And businesses have come to us in the past and have said, look, this person's terribly performing. I want to terminate their employment. I want to make them redundant. And I say, well, do you still need the job? And they say, you know what, I don't. They've done such a bad job for the last 12 months that they've actually ruined that part of the business, or they've changed my mind and I no longer want that role. I want a more junior role. I want it doing something else and doing slightly other duties. That's slightly messy, but in my view, doable if it's done right. I wouldn't recommend you run off and do it on your own. Always get advice. I always say in these sessions, make sure you get advice from your lawyers or your external advisors. And if you don't have one, we're here. You can always ring us. And if you're members of an employer association like the New South Wales Business Chamber, or you're a member of something like Workplace Assured, always ring your advice line before you do anything. Now, group redundancies, when we're talking about more than one person being made redundant, there are a range of ways you can do that. There's voluntary redundancies, and I'll talk a little bit more later about how you do that. You don't have to effect voluntary redundancies unless there's something in your enterprise agreement requiring you to do it, which we do find in agreements in industries. There's the spill and fill approach. That is, you might have 5 people doing very similar roles or the same role, and that is you only need 3 of them, as Emily already talked earlier today about, 5 reducing to 3 is a good example. And in fact, I've had quite a few circumstances we've had 5 reducing to 3. That means you then need to go through a process of, well, how do we pick this person? And it often will involve criteria like the skill level of the person, the experience, the qualifications of the person. You've got to be careful about length of service. Length of service, if, for example, you're making a decision because a person's been there a long time, it'll cost you a lot to pay them out in terms of accruals. Even though that's a flawed approach, in my view, it's legally potentially problematic.
Some employers do it, last in, first out.
Yes.
As an objective way of deciding who's going to be made redundant.
That has historically sometimes proven to be problematic in certain industries where you might find that there's an older workforce and that it might tend to discriminate against young people who have only just started, and ultimately, indirectly, they've been discriminated against because whilst the policy is not around their age, it tends to discriminate against them regardless. And it may or may not be a reasonable policy, which needs to be one of the elements of examination of a discrimination claim in those circumstances. We would tend to be careful around length of service. It might be something that goes into the list, but it's something that we think you need to be very careful about in particular industries. One of the things we'd suggest you steer away from is the unlawful criteria. And I have often seen, and I've been involved in industrial disputes and unfair dismissal claims involving employers who have unfortunately included on their list, sometimes even an open column, how much sick leave has this person taken, or frequency of absences.
You don't want that to go on your assessment,
No.
on your skills matrix.
No, you don't. You do not want it on there. I've seen it written on there before. I've even seen line managers write too much sick leave, and that's been a criteria that's been used to select people before, tip them over the edge because they're performing as badly or as well as someone else. It should not appear anywhere, and it should not really be one of the considerations that you have. Other absences might be also that they're taking carers leave, or they might have exercised their rights in relation to annual leave, and it might agitate the employer, long service leave. And then also less common than sick leave is complaints. If any of those considerations are on your list or are in your mind about a selection process for redundancy, then you could have some problems later on. It won't be an unfair dismissal you'll be facing. It will potentially be a general protections claim or a discrimination claim, which are very similar but also different, and often more costly than an unfair dismissal.
Yeah, absolutely. And we get a lot of general protections claims after a redundancy where the employee has made the general protections claim alleging that either the redundancy wasn't genuine because it was a ruse to get them out because they've either taken sick leave or they've made complaints. It's just becoming more and more common. We're seeing more general protections claims, I would say, at the moment than unfair dismissal claims.
Yeah, look, I'd have to say when it comes to genuine redundancy, where they have a representative, they do tend to go down the general protections.
And that's also where when you're going through the consultation process with your employees, if you've got everything documented and you go through a thorough consultation process, that can really assist in successfully defending a general protections claim where the employee is alleging that it wasn't a genuine redundancy or it was for these reasons. If you've got a proper documented process, that can be really helpful.
Yeah, well, and that feeds back into what we've talked about today already, and that is having your plan and having a good communication strategy, both a group one and an individual one. And sometimes it might just be an individual you're looking at, and that really having that plan and having that open communication, or at least an attempt to communicate, because what we've found in a lot of the cases, Emily and I work on a lot of these cases together a lot. And what we find is that often the individual who's off on sick leave or workers' comp is not compliant with the employer's attempts to engage with them and meet with them. So you still need to make the attempts and make repeated attempts. Don't give up at the first turn where you get resistance, because you need to demonstrate that you're a reasonable, loving and caring employer. And you do that by turning the other cheek when the employee's, screaming complaints at you and alleging unlawful behaviour, and continue down that path of lawful termination for redundancy. So what have you got to pay? Em?
Oh, so when... sorry.
That's right.
So when you're looking at making someone's role redundant, obviously there are the National Employment Standards have a minimum redundancy payment. There's a table, I think it's in section 117 of the Fair Work Act, and it sets out, if you've done over 1 year, it's 4 weeks, and the table goes all the way up to 12 weeks. It actually goes up to 16 weeks, I think, at the 8-year period or 9-year period because of there was an operation with the way it interacts with long service leave. So obviously, because you're terminating someone's employment, there'll be a period of notice which is payable. Employers sometimes, when they're looking at redundancies, they pay in lieu of notice, and that there'll be a consideration as to whether you want this person to remain in the business working out their notice period, or whether you would like them to finish up then and there, be paid in lieu of notice. So they'll receive whatever that period is, depending on their period of service or what their contract might say. Some contracts just have a flat 4-week notice period, and the NES would override that if the person is over 45 and has more than 2 years of service. Then you would have that additional week in the National Employment Standards. You would then have the redundancy pay. Sometimes there may be contractual entitlements to bonuses or other incentive payments where someone has because of the way that their contract is worded or their contract operates, then they have a contractual entitlement that would arise to those payments. Also, long service leave. Depending on what state you're in, there may be a pro rata long service leave payment that you need to pay to your employees. I know in Victoria, that's recently been reduced to 7 years just to have that entitlement applying. In New South Wales, it's pro rata after 5 years. South Australia, it's pro rata after 7. So it depends on your state, but that's also something for you to think of as well. Also, if you've got an employee who's got some accrued annual leave, which they would be entitled to in any event, whether or not the employment's being terminated for redundancy. And also then superannuation is payable on the notice payment.
Yeah, and look, there might also be somewhat unusually, but not entirely out of the question. We've come across this recently, a payout of accrued sick leave that hasn't been taken. Now, sometimes you'll see that in an enterprise agreement. It's not common, but it is sometimes there. We've come across it in recent times again. We come across it a few times a year. There might be a policy or there might be a custom and practice in the business where they pay out sick leave on termination. But an employee is not entitled to be paid out their sick leave unless there is, at law that is, and legally speaking, under the Fair Work Act, unless there is a provision in the award or the enterprise agreement that requires the payment of paid personal leave, paid sick leave. Now, none of the awards, to my knowledge, have any requirement on employers to pay out personal or paid sick leave on termination. But we do come across the enterprise agreements from time to time that do have that requirement. So it's really important that you do include that. There is something I wanted to say. I'm just going to go back a slide. It is really important, and those of you that have seen me speak on these webcasts from time to time, you will know that I bang on a lot about contracts, because contracts are really important, particularly around the time of termination of employment, even for legitimate reasons like perfectly legitimate and lawful and not, messy situations like redundancy. Which should be, as I said earlier today, business as usual in many businesses these days. But if you do not have up-to-date contracts, then you can be exposed to a reasonable notice claim. And I've had a number of cases over the years where individuals have been genuinely made redundant. The employer no longer required their job to be performed by anyone. They were consulted with, their redeployment was considered, but they didn't have an up-to-date contract that was relevant to their employment. And they came back for a second bite of the cherry. And they said, you know what, thank you for the 16 weeks pay because I'd been working there for 9 years, or 12 weeks I've been working there for 10 years. And thank you, by the way, thank you for the extra month's pay that you gave me because you were being generous. And thank you for the notice payment. And thank you for getting all my payments right. But guess what? I want reasonable notice. I don't want 5 weeks under the National Employment Standard, because that's a minimum period, not a maximum period or not the actual period. So if you don't have a contract that provides a specific period of notice or another legal obligation to pay a specific period of notice in an enterprise agreement, and potentially in a policy, although I wouldn't be comfortable with a policy, then you can be exposed to reasonable notice. And it is a bitter experience for an employer. So you need to, one of the actions for those of you businesses on the line, if you're considering redundancies or you think that in the next 12 months you might be making redundancies, if it's happening in the next month, it might be a bit contrived to put contracts in place now, then you need to make sure your contracts are in place. That's for a whole range of other reasons, but redundancy is on that list of reasons why you need to make sure you've got contracts in place. It's a very bitter experience. The other thing is around policies as well. I just wanted to very briefly mention that. Em's already talked about it, but do you have to comply with your policy? Look, it's always our recommendation that you do. If it is purely a policy at law and it's not contractually binding, then potentially you don't have to comply with your policy. Got to be careful about that. But if you, again, don't have a properly worded contract or you don't have a contract at all, then there's a real risk that the policies that you have in place are contractual in nature, if they're promissory in terms of the language, and if they've been around potentially, even if they've been around since the employee started their employment there. So you might have a contractual obligation under a policy to pay something. And lastly, I just wanted to come back to bonuses or incentives. If you do not have a properly written contract and bonus policy that might go with that as well, around your discretion to make those payments, if it's a discretionary policy, or you don't have the right language around the employee needing to be employed at the time the bonus should be paid, then there may be, and there likely is, an ongoing obligation to pay that person a trailing commission or a bonus, even though they have been made redundant and are leaving the business. There's plenty of cases out there that talk about an obligation to pay someone their bonus unless there's the correct wording in your contract. So that's another reason you need to have your contracts up to date with the right wording in them as well. That's the scale that Em's already talked about. As you can see, Emily talked about at the 9 years point, it's hit 16 weeks and it drops back, and that's a strange relationship with long service leave. That's probably not entirely fair in my view, but it is what it is. So can you pay less than the National Employment Standard payment scale? So yes, there are exceptions. If the employee is a true casual, and now we can spend a whole session talking about what a true casual is because of the controversy in the last couple of years around the work pack and scheme decision by the federal court and the full federal court. But you need to be careful that they are truly a casual. If they're a regular and systematic casual with an expectation of ongoing work, then they're probably not really a casual at common law, and you might actually have to pay them redundancy. So be careful about offhandedly dismissing whether or not a person is a casual. Fixed-term employees who are true, fixed-term employees who their employment was to come to an end at a specific date, well, that's not a redundancy. They're only employed for a fixed term or a specified period is the right language under the Act. Apprentices who work out their apprenticeship won't be entitled. Generally, trainees and interns generally won't be entitled. Again, I would ask you, just like I have in the case of casuals, to make sure that you go back and check whether or not they are the arrangements that are in place in relation to the apprentice, the trainees or the interns, and even the fixed-term employees are appropriate and such that they are actually excluded from redundancy pay. But the general rule is they are not included. An employee with less than 12 months service, the scale, as you will have seen, doesn't provide that. So you had to have worked at least 1 year, but less than 2 to get your first lockstep. Otherwise, you get 0. Small business employers have an exemption where you have less than 15 employees. For those of you running family businesses, be careful about who you've got on the books as an employee. If you are paying family members, but they might do nothing, technically they might still be an employee. So your head count might be more than 14, it might be 15 plus. So be careful about that. And also you can make an application through the Fair Work Commission to have that redundancy pay either reduced in part or in whole if you have an incapacity to pay or you have obtained acceptable alternative employment for the individual. Now, that means you have to have obtained the acceptable alternative employment, not the employee went out and got a job somewhere else and you gave them a reference. That won't get you over the line. It may be that you're transferring part of your business to another business, and you may have arranged for them to have a job and you might have a case for that. I would ask you to approach both of those concepts. The circumstances where you have an incapacity to pay, you'd need to demonstrate that you're struggling to pay your bills and, you know, that the business was near on impecunious, in my view, before you get that exception. And likewise, it is quite a high bar for acceptable alternative employment. And then there's transfer of employment rules. Do you want to talk about those a bit?
Yeah, I can talk briefly. I'm just mindful of time as well. So when you've got a transfer of employment situation where you may have sold a business, maybe an asset, a business sale, and the new employer is going to keep your old employee. So a redundancy arises because for the vendor employer, which might be ABC, Pty Ltd, that person is selling their business to the purchaser. The purchaser will be the new employer. So genuinely, the previous employer in that case no longer requires that role to be performed by anybody. But where the new employer takes on the employees from the vendor and that new employer agrees to recognise their service for the purposes of redundancy, then the seller will not have to make a redundancy payment to those employees. It's usually dealt with in the sale agreement, the business sale agreement, but the Fair Work Act does come into play, and there are sections in the Act around what happens in terms of recognising people's service and where the requirement to pay the redundancy would arise. So it would arise if the new employer is not going to recognise their service and lets them know this in writing prior to them commencing employment with that new employer.
And the only other requirement is to make the offer to the new employees, and Emily's referred to as generally taking them on. But the other condition is that the job that they are going to perform for the new employer is substantially the same on an overall basis as their job with the first employer.
Yeah. And the Fair Work Act will deem there to be a transfer of employment in certain circumstances as well. So it's quite a technical area, and it's a really good idea to get some advice if you're in that situation.
Definitely. Now, just quickly on notification requirements, we'll rip through these. You've got to notify Centrelink if there are 15 or more employees. There's some requirements in the Act to do that. Where that termination is for reasons of economical, technological, structural or reasons of a similar nature. You have to provide the written reason for the terminations as well, and you have to provide the number and category of employees, not their names. So there's a process to follow that. I think there's a form that you can fill out. I can't remember. It's been a while since I've had a look at it. I remember last year I think we looked at one and we dug the form out for a client. 15, of course, is a lot of employees. But you need to notify them. You also need to notify, in circumstances where they have a union, you need to notify the union in the same circumstances. You will also have an obligation, as we've already discussed, where there's award coverage, to have already engaged with the union as part of the consultation process when you're engaging with the employees, because the requirement is you engage with the individuals who are affected and their representatives. That's the other requirement. So you'll need to engage with the union. Part of that process should be built into your strategy, and that is notifying ultimately at the end how many people have been made redundant. They'll usually know, but you need to formally notify them about that. How do you affect the termination? Em, maybe take us through this.
Yeah, look, it's always best practice to have a face-to-face meeting, obviously where that's reasonably practicable to do so. In most cases it will be. Joe mentioned before there might be situations where you've got an employee who's being belligerent and who's just not engaging with you in the process. That's a rarer event. So face-to-face meeting, you would want to have some, sometimes we do this with employers. We'll help them with a script that they can have just as a guidance of what they want to say in the meeting. And you want to also, at that meeting where you're letting the employee know that their employment is going to be terminated, you give them notice of termination in writing.
And there's nothing wrong with preparing a script in advance. It sounds contrived because you've got a script, but it is important in circumstances where there are a range of things you must say or you should say. And it also helps you from going off track. And it also conveniently dovetails into the last stop point here, and that is documenting the process. If you say what is in that script, then that becomes your file note effectively. So you can convert that script into an easily made file note. If we've prepared it, it means you just cut and paste the text into another document. You add the extra comments that were made by the individual who's being made redundant, and it becomes your file note. And it's a very nice way to in a risk-averse way, affect determination.
Yeah, and these are not easy discussions to have. Like, this is not, it's not a discussion that an employer, relishes having with its employees, and they can be quite difficult. So if you have some points prepared in writing, whether it's in a, as comprehensive as a script or just some dot points, just to make sure that you're covering off those points that you need to make, because they can be quite difficult discussions. You don't know how the employee is going to respond. And so it also helps if the employee is going off maybe on a tangent of complaining about something, it can help you to bring the discussion back to the points that you were wanting to make.
Yeah. I might just quickly take us through leaving the workplace. This one's an interesting one, and it's one that also creates some tension around the consultation process. But this often happens with individuals where you don't have a consultation requirement because they're usually in the workplace during the consultation process, not always, but usually. But where you do have a need to remove someone from the workplace, then you usually can, provided it's a legitimate reason. In most circumstances, you could require employees to work out the notice period. It's generally not referred as considered to be entirely a nice thing to do in circumstances where they're being terminated and they're sort of the walking dead. walking around the workplace knowing their employment's coming to an end. Everyone, or at least a large portion of people, know their employment's coming to an end. It's not nice. But legally speaking, there are many circumstances where you can require a person to work out their notice period. It might raise a question around the genuineness of the redundancy sometimes. So it's a careful decision that needs to be made. It's not an automatic situation. I've got up here gardening leave. It's not really a term that's one that you should bandy about a lot. People generally know it as being gardening leave. You put them out on the grass, or you put them out of the workplace during the notice period and don't have them in the workplace. There's a whole range of reasons you might do that. Security of confidential information, security of client lists and clients. Also, sometimes industrial sabotage. That can happen. You don't come across it a lot, but it does happen occasionally. And that is people feeling embittered about losing their jobs and they don't feel it's just. So there are reasons why you might require someone to remain away from the workplace. Immediate termination is a consideration when it comes to non-agreement or award-covered employees. That is something that happens a fair bit, and it helps employers manage their anxiety. It does sometimes come at a cultural cost, and it does also sometimes come at a cost of the individual being more likely to take legal action against the business if they feel that they've been blindsided by the redundancy and then marched quickly from the workplace. So we would ask that you give that careful consideration before you head down that path of a hasty and quick dismissal. But there are a whole range of considerations there, so I can't give you the usual way we would advise about that without understanding the facts and circumstances and your particular concerns around this. Farewell events. Look, they generally go well, but occasionally you hear a story about someone either drinking too much and telling people what they think. We hear sometimes about people who stuck around after the event and got to hear the war stories in a different light from the individual who's leaving the business. So again, we'd ask you to carefully consider farewell events against the background of that person's employment with the business and how you have conducted the redundancy. Management of ongoing staff. We might quickly rip through this so we can get a couple of questions. Just remember, sometimes some people suffer from survivor guilt when there's lots of redundancies. So it's important around your comms strategy to make sure that you have communication that flows at the event and after the event, as well as before and during the consultation process. They feel a loss of colleagues. You've also got to manage the optics of fair treatment around individuals in the workplace. And sometimes that can damage the individual's confidence for you to manage the business going forward and their interests and to look after them. That's really important in today's day and age, where we've got, millennials who are looking to their leaders more than ever for setting the right example that's fair and reasonable. It's really important you give that to consideration. We've already talked about the anxiety around added workloads, and that is, people who are going to be left behind might also be getting additional work. Part of your communication strategy, part of your strategy around affecting the terminations needs to be dealing with the individuals who are affected, and people with added workloads will be affected. If even people who are not going to be affected need to know that their job's not going to change, if that's the case. And lastly, put in place some support mechanisms sometimes for those who remain, and that might be your employee assistance program. Sometimes we've helped businesses bring people in to do a team building exercise after a redundancy process, which is something we would recommend in circumstances where you think that the staff are going to be affected by people leaving. Quickly on voluntary redundancies, when is it required? Well, it's usually required when it's in an enterprise agreement, but sometimes it can be a policy of the business. And in those circumstances, we'd normally recommend it. It can where it is a redundancy process, however, it can be a real problem where it can result in the loss of your best talent. And unfortunately, the best people often are the ones to put their hand up because they can go and get a job tomorrow. They can get a lump sum payout. And if there's a few cultural things happening in the workplace because things haven't been great and redundancies are on the horizon, they might say, you know what, I might take one of those and I'm going to go get another job somewhere else. It needs to be, it can reduce cultural friction sometimes, but it needs to be balanced with the business need and your understanding of your staff, assuming you've got a good understanding of that. rehiring?
Yeah, can you rehire someone? Yes, you can. There may be, again, I'll just quickly go through this. There may be some tax implications because if you rehire someone, I think there's a period of time within which, if they're rehired, the ATO might be a little bit keen to see a little bit more tax taken out of that payment that they've received. And it can have an impact on continuity of service and the legislative requirements around that. So, but yes, you can. There's nothing to stop you from doing that.
Just continuity of service. The long service leave acts are different around the country. Em's already pointed that out. But in relation to continuity of service, some of the acts say if you recommence employment within 2 months or 3 months, and in fact in WA, I think there's a provision that says that if you've terminated someone's employment because of a downturn in business, and then you re-employ them within 6 months, I think you were looking at that about 4 months ago. If you re-employ them in 6 months, then there's continuity of service from previously, and they immediately continue to accrue long service as if they were a 5, 6, 7, 10-year employee. So common questions, we'll get through these, and I note some of the questions here actually mirror some of these. Can I make someone redundant when they're on workers' comp or sick leave?
Yes, you can, but tread very, very carefully.
Yeah. And as I said earlier, you need to treat that person as if they weren't on workers' comp as best you can. That means if they would have been made redundant while they were not on workers' comp, then you make them redundant. But do not use the fact that they're on workers' comp or sick leave to be a reason. Can I make someone redundant when they're on parental leave? This is a really interesting one. I've got to be careful about this. So there's a couple of federal court and federal magistrates court or circuit court decisions that suggest you can do this, and certainly that seems to be the current legal position from a judicial perspective. I have a particular view, and I think that you've got to be very careful around terminating someone when they're on parental leave during the guaranteed period, because people have a view that the Act says you're guaranteed to have, up to 12 months off, and sometimes it can be extended because you've got a right to request an additional period if you like. Doesn't mean you get the additional period, but a right to request. So during that 12 months, let's say someone takes 12 months off, they have an expectation. The Act says you've got a guaranteed return at this date, and the return says either to that position or a position that is similar in terms of commensurate in terms of status and pay. So there is that expectation. There are a couple of court decisions that say that you can terminate earlier if it's a genuine redundancy in all the circumstances. But there's lots of litigation that's happened when you terminate someone's employment. So you need to be very careful and ring your advisors if that's the case. Can I force an employee to transfer to another job instead of them being made redundant?
No, you can't.
No.
You've got to consult with them about that. They can agree to be transferred to another job, but no, you can't force them.
Yeah, so those they might end up not being entitled to redundancy pay if it's a transfer of business circumstance. And in terms of redeployment, it wouldn't necessarily be reasonable to redeploy them into another role. You can't force them to sign a contract. You can't force them to go and work with another employer. So you can't force them. But as Emily says, you can ask them to agree. And lastly, can I ask for a deed of release when I make someone redundant?
Yeah, so we get this a lot as well, where employers want to present a deed of release, which only provides for those employees to receive their statutory entitlements, which they would be receiving in any event, whether or not they signed a deed. So again, this requires some careful consideration. You can ask for it. We would generally recommend that if you are going to present a deed of release to an employee, that there be some additional incentive or an additional consideration to them for signing that deed of release, because you also need to give them an opportunity to go off and get legal advice. And if an employee went off to a lawyer with a deed that purely provided for them to receive their statutory entitlements, that lawyer would very quickly inform them not to sign that deed, because there would be no reason why they would. Sometimes you can provide outplacement services. We've seen that as well, and that may be something which assists an employee who's being made redundant to then go back into the market with additional skills that they get as part of outplacement. So that can also form part of a deed of release.
Yeah. So that brings us to the end of our session, and we're sorry for those of you, we went a little over time, a couple of minutes over time, but we've got up here our little how can we help screen. What we're going to do today is send out a redundancy checklist.
Yep.
If you have a need for any particular document, I've talked about contracts today. Contracts are my thing. I do not let them go. They're very important and very disappointing when the client turns up without the right contract. We do all sorts of employment work, so you can ring us about employment and industrial work if you need us. And we're, of course, associated with the Business Chamber, so you can call us if you want to become a member, and we can refer you to the right person so you have access to that advice line. But Emily, thanks for joining me today.
Thanks, Joe. Thank you.
Thank you all for joining us, and we'll see you next time.